Well, thank you very much for that. Now, with a bit of sophistry, I could probably relate what I'm going to say to the theme of the conference, but I'm not going to try. So thank you very much, Owen, for the indulgence. Now, I'm on a mission at the moment to sell throughout Europe, and certainly the EU countries, the concept of what I would describe as national environmental audit and enforcement bodies. Now, I've long been interested in how we do ensure that governments and public bodies comply with their environmental law duties, whether it's EU law or national law. And I did work in the European Commission enforcement unit for a short time. That was many years ago when Ludwig Kramer was head of the unit. Now, Ludwig Kramer refused to have any sort of prioritization policy. He said, I remember him saying, I used to argue with him about that, he said, well, how can I compare loss of a habitat in Ireland to air pollution in Athens? I'm going to, every complaint we will investigate and decide what we're to do. Now, my own view is that actually all enforcement policies, they never have enough money, and you have to have some sort of priority policy. But it should be very transparent what you're doing, so everybody knows. And indeed, from 2000 and, let me see, get the right way. No, I'm going the wrong way. Oh, now that's interesting. Oh, no, there we are. In fact, from 2017, well, this is the current one, it started a bit earlier, after Ludwig Kramer left, the European Commission has developed a prioritization policy for the infraction proceedings they will take. And this covers all areas of EU law, not just the environment. And you can see there's a clear indication these are the priorities: non-communication, non-compliance with judgment, and then a rather vaguely worded ones, important EU policy objectives. But they then go on, and it's very important, to say that individual cases on non-implementation in practice will be directed at national level, unless wider principle of systematic failure. So that's a very clear indication that actually lots of these cases should be handled at national level. And I think the Commission imagined that, I mean, judges, national courts, normally can't initiate their own cases, they have to wait for litigation. And I think the Commission imagined that with Aarhus coming on board, relaxed rules of standing, liberal rules of standing, limited costs, this would deal with the problem. But I want to argue that this simply isn't sufficient. And to think why there isn't actually a need for national enforcement bodies. So really the question is environmental litigation, can you rely upon that by NGOs alone? Now, as you all know, the UK on Brexit did set up an environmental audit body, an enforcement, which I'm going to come back to. But it wasn't plain sailing setting this up, it wasn't obvious. And the UK government initially said, we don't need such a body. And I think they gave an argument, which I think many EU member states, I suspect including the Irish government, would say, well, why do we need it? NGOs can always take us to court, and they do take us to court, and we're responsible in that way. We don't need another body. Now, cases against the governments and public bodies by NGOs will continue, and they will be very important. But I don't think they can replicate the functions and role of a national independent body. And so you ask, well, is environmental litigation sufficient? Well, I'll give you a few arguments where I don't think it can be. First of all, it's clear if you look across Europe, and I'm not necessarily talking about Ireland, there's some very powerful NGOs in Ireland, and there are in the UK. Actually, the strength and experience in litigation of NGOs across Europe is completely variable. In some countries, they hardly exist. Also, NGOs, naturally, they have their own priorities, their own membership, their own focus. And often they don't focus on areas of what I would think of as environmental law is quite significant, but has quite a low public profile compared, say, to waste pollution, air pollution, climate change. I mean, take something like contaminated land, which is a really difficult area of law, and so on. We don't get many NGOs taking JRs about contaminated land. But thirdly, and I think this may be the most important point from my own experience, as you will know, when the Commission initiates infringement proceedings against a member state, it is actually able to settle something like 90% of the cases without having to go to the European Court. But when an NGO brings a case against government, in my experience in the UK, or a public body, it's much more difficult to conduct that sort of negotiation. If you look up, I'm sure it's the same here, RJR procedures or the rules of practice, they say, you know, there should be settlements, mediation, all of that, but it doesn't really happen. And one of the reasons, anybody in government will know that, if you're dealing with government, you've somehow got to not let them lose face, you know, to concede, but losing face is very important in public profile. And it's not easy if you're negotiating with an NGO. And also NGOs, quite rightly again, often do want the day in court. That's quite important, and actually it's difficult. So I can at the moment think of only, I keep pressing the wrong button. They're obviously in every country in Europe has ombudsmen. But normally they're not specialised in environmental law. They sometimes take up environmental cases. And in most countries they are confined to what we'd call classical maladministration. And normally they do not go to court or threaten enforcement actions. The three cases I give very briefly, which I think are the only three examples of getting something to what I'm conceiving of. There's the public prosecutor in Portugal, which obviously is dealing with a lot of criminal prosecutions, but they have a function which is called defending interests laid down by law, and that has been interpreted by the courts as including environmental interests. So they do have cases where they will, for instance, threaten a local authority if they think they're going to do something illegal, contrary to public law, and actually have impact on that. The problem is that they are, the specialist environmental law with the public, it's very small, and I think they, in 2023, when I looked up, they just filed 7 cases only, and we're finding it quite difficult. Austria has what they call regional environmental ombudsmen who go beyond maladministration, and they can both participate in licensing procedures, those sorts of planning applications, and more importantly, once they've participated, they can go to court to challenge that legality, and they do. But they don't have a general role of enforcement of public law duties. And indeed, they only operate at regional level, so there's no equivalent federal. And then I suppose the closest to my vision is something called the Hungarian, the Office for Future Generations, which sits again within the Ombudsman Office, but has roles which are far beyond what we'd think of classical ombudsman. And they can challenge laws, government laws, as being unconstitutional, and have had some success where government has tried to roll back, for instance, forestry laws, and they've challenged that law, and the Constitutional Court said this is contrary to environmental provisions in the Constitution. They certainly act as mediators between government and local interests, and they investigate issues, but they don't have what I'd call a general enforcement function. If there's a breach of public law, they don't have any role to go to that. So then we get to the British examples set up after Brexit, and of course because of Brexit. And it was a bit of a campaign, as I said, it wasn't obvious, but NGOs and academics began to argue the initial Brexit approach was we will simply roll over all the EU laws, keep them going for the time being, and that was quite sensible. But a number of academics and NGOs said, yes, but that's just the black letter of the law. What about the institution? Who's going to replace the Commission, which have been, as you know, pretty active on the environmental field, including Britain? And eventually, a new Secretary of State agreed, and initially wanted to set up a UK-wide body, but we have devolved powers, and talked to Scotland, and Colin Reid is here, and the Scottish government said, we're not having a British UK body, we're going to set up our own body, which they've done, Environmental Standards Scotland. Wales said the same, and Wales is actually in the process, they've just published the laws, passed the laws to set up their own body. So the Office for Environmental Protection, its jurisdiction covers England. Northern Ireland, perhaps surprisingly, or unsurprisingly, said, we just haven't got the resources to set up another body, public body in Northern Ireland. Will you take over the jurisdiction? So it's got Northern Ireland as well. And I'm going to focus on the OEP because that's the body I know most about. I was on the board until last year, left now, If you want to know about Scotland a bit more, Colin, I think, where is Colin? I don't know, I can't see him. But Colin can tell you about that. Now, it has a range of functions, including advising on new environmental laws and policy functions, but I'm going to focus on, I think, the two most relevant functions in this context about enforcement. The first one, it can investigate, and has a duty, the implementation of environmental law. Now, the legislation doesn't define what implementation means. OEP has got a complete discretion how it goes about that. I think the interesting thing is that we've never in the UK had a body that does this systematically. If there's a scandal, a parliamentary committee can be set up and we'll look at that. There's very little legislation, I could give you about 3 examples, which has a duty on even the government to review the implementation after 5 years, what's going on, what's actually happening. So we're not very good and not very systematic about that. The important thing is that, first of all, there is a duty to cooperate with the OEP, and I'll come back to that. It is quite important, actually, to make sure you've got that. They can't just sort of hide behind and not give you any information. And I think the probably important thing is that the reports are published before Parliament. They are not binding on government, and I don't think they should be, but government has to respond to the reports within 3 months. So they can't just gather dust. I mean, there has to be an argument why you don't do it. And the OEP has now published a number of reports, and I'll give you this one, which came out last year, about inspections. And it was a really interesting report, which I don't think anybody's ever done before, even academics, where it took about 30 environmental agencies, bodies, local authorities, and said, okay, do they have any duties to inspect? You know, where do we know that with the industrial emissions directive, or whatever, there is a certain duty. But is there any duty? Is it a completely discretionary duty? Does it just say may from time to time? Or is it, and of course, as you look at any environment, you know, it's all a bit different. And what is the actual practice? So this actually drills down in a lot of detail. Again, not binding, but I think really useful. And indeed, it was picked up by UNEP in Nairobi, United Nations Environment Programme, who said, I didn't write it, so I'm not a flashing writer. They said this is the best report we've ever seen on the whole problem of inspections and the recommendations, and we're going to pick up some of these to do that. So I think that's very important. And one of the things that I didn't think when this legislation was going through is, of course, if you're doing an investigation of a whole area of implementation, you then can pick up, well, hang a moment, what they're doing in practice isn't complying with the law. So you pick up breaches of the law, and that has happened in some cases. So the second main function, and it's the one that got perhaps most political attention when it went through court, and this is the closest, well, actually the European Commission does investigate areas of law, so that's equivalent, but the enforcement was the interesting thing, is that it has the power to take government, local authorities, and any public body to court for failures to comply with their environmental law duties. And I should say initially that environmental law is defined in the legislation. And it basically says it's any area of law which is mainly to do with environmental protection. So that means all the kind of familiar areas like nature protection, air pollution, climate change, and all of that are within that. But to give you an example, general planning law, something like myself, I think, do a lot of planning, general planning law is not mainly to do with environmental protection. So that's outside the remit of the OEP, I think quite rightly. On the other hand, within planning law, you get things like environmental assessment regulations. They clearly are mainly, so we can deal with that. And I'm actually given the OEP the fact if we had to deal with all the planning disputes as well, didn't do it. So it's not dealing with, there may be areas of law which have significant effects on the environment, but that's not its remit. So that is important, it's not doing everything. But it's a form of judicial review, but the differences with normal judicial review in the UK, or England I should say, I have to be very careful, and I'm not sure in Ireland, is that you don't need leave from the court to bring a case. In the UK, there's an initial leave stage to weed out hopeless cases. We just go to court, and perhaps even more importantly, there are no time limits. Normally, is it 3 months here? I mean, it is in the UK, if I remember. So it could bring if you like, a JR. It's called an environmental review to show the distinction. It could be a year or 2 years, and so on. If there are third-party interests affected by that, the remedies of the court may be limited, but I can deal with that in a question. But the focus is on the breach of the duty. It does have, actually, an emergency power if it thinks that the process that it's going to go through, this three-stage process, you'll see there's a three-stage process: information notice, a decision notice, and then going to the court. And basically there is a minimum of 2 months between each one. And clearly that process, which replicates the commission, the letter, the reasoned opinion, is designed to encourage settlements and mediation and discussion before you get to the next stage. But, as I said at the last, if OEP thinks there is a breach of environmental law and it's going to lead to significant or is environmental damage, and this process is too long, it can go for an emergency action and a normal JR before a court. It will need leave. Now, it's only threatened this once in Northern Ireland. Is anybody from Northern Ireland here? I'm sort of half from Northern Ireland. Nobody from Northern Ireland. Anyway, and it was in respect of government advice, quite interesting actually, to local authorities on the acceptable levels of ammonia from proposed livestock units. And we looked at this and we thought these are very generous ammonia levels. Obviously farming interests had helped. And they were way out of scale with the similar ones in Scotland and England. And we thought actually, basically, it's Wednesbury irrational. You know, this is illegal. And threatened it, and we decided going through this was taking too long, and actually got to a pre-action protocol letter, you know, quite serious stuff, and then the government conceded. But it was very, very political, and they withdrew it, so we didn't have to get to court. We would have won, actually, on that particular one, because they, unfortunately, they also somehow leaked some internal legal advice which said, we think this is illegal. You know, that did help. Anyway, and you can see these it will be very public when it takes an action, and this is one about marine targets, which they launched. Now, it's been going, the OEP, for just over 3 years, and there are 24 looking at their website. It's all on the website. It's quite difficult. All the documents are there, but it's not terribly sort of accessible in a way, I don't think. I'll come back to that. But it's been going just 24 years, and as yet, it hasn't had to get to court. It hasn't had an environmental review. Some of the judges I've known talk to, they're salivating. They want one of these to see what will happen. I think it will in the next 2 or 3 years, and I think actually it will be about interpretation of law, which you cannot reconcile. You know, governments, we've got another one, or OEP, I mustn't say we, I'm not on it anymore. OEP's got another one, and they just have to go to court. I think that's what will happen. As I said, no environment except this emergency one yearly. And basically pretty tough settlements which were negotiated in all cases. And again, that's all the documentation public. Interestingly, 80% of these cases so far come from public complaints. And again, the legislation, very like the Commission, although it's not in the legislation, the OEP has to have a public complaint system. Anybody can complain to it if they think there's an alleged breach. And the cases are split roughly between, you can see here, England and Northern Ireland. It's about half and half. And nearly all, I think when it was set up, I don't think there's any from the government departments, I've talked to some of the officials, they all thought, well, we're going to be off the hook, it's going to be local authorities being done. Actually, nearly all the cases involve government departments, either DARE in Northern Ireland or DEFRA in UK. Very few local authorities involved. And I think that's because both the legislation makes clear and the OEP's prioritisation makes clear is that they are concerned with big strategic cases of wide significance, potentially. That's what they've got to focus on and where they'll make a difference. And so it's quite obvious, you know, a single decision by a local authority, I don't know, to chop down one tree. Now that may affect somebody locally quite a lot. It's unlikely the OEP will pick that up unless they can see there's evidence that this is an area of law which is being mishandled by a lot of local authorities. And these are some of the examples of cases where you can see where England, failure to publish statutory targets of the deadline in the legislation. Ironically, they said, well, actually, we'd gone out for draft for consultation. This is on new environmental targets. And there were so many responses, 130,000, we couldn't handle them in time. And OEP said, no, you've got to. Again, another deadline. Now, deadlines are very easy because it's obvious there's a breach of the law. And what you're trying to find out is why did they miss the deadline, what's the excuse, and when are they going to remedy it? So that was done. I've mentioned the ammonia guidance, another one, England. Interesting one, Environmental Agency controlling waste exports, meant to be going for recycling to India. That had interestingly, that's an example of a case where NGOs were also about to take a judicial review, and there was a BBC programme, and everybody was involved in that case. And then in Northern Ireland, a review of the Nutrient Action Programme. And I'm just going to give you just two examples, a little bit more detail, just to give you a flavour of what it's like and some of the cases. The first one was the OEP had a complaint from an individual near a waste disposal site. And the waste disposal site, the operator had gone bust. And normally there's meant to be, as you probably know, I'm sure in your laws, there's meant to be adequate financial provision put up front to sort of deal with that. And they reckoned, and we looked at, the AOP looked at that and said they didn't think the Environment Agency had properly assessed and required the financial guarantees that there should have been. There was something wrong in the process. Then looked a bit further and thought this is not just a single case. This is actually happening throughout the agency. They haven't got a proper system to do with that. And in fact, the agency then, the Environment, agreed an action plan to review how it does actually deal with financial assessment, and the OEP said we were going to monitor that and see it's implemented and so on. So we won't take this further at this stage. The second one is very, for those interested in constitutional law, I'd call this concerned the Department of Agriculture, Environment and Rural Affairs in Northern Ireland, and I'd call this really going to the wire. This is where it gets, really interesting. In 2023, OEP wrote to the Permanent Secretary of DARE in Northern Ireland saying the Northern Ireland Improvement Plan hadn't been laid before the Assembly, but on July the 23rd, 2023, as the legislation explicitly says that date, and there's no ifs and buts. But the OEP did acknowledge there were difficulties because there was then no executive or assembly, it was in suspension. But they said, look, any delay has to be as short as possible. The Permanent Secretary then wrote back to the OEP and said, whatever the legislation says, the Environment Act, because the EIP, the Environment Improvement Plan, was what's called a major new policy initiative, the civil servants couldn't sign it off constitutionally. And there's some very complicated law on this, and there's been some case law in other areas, really complicated judge trying to work out if there's a conflict between an Act of Parliament and these internal rules. Anyway, so the civil servants, we can't do anything until the executive is reinstated. Now, we did recognise, the OEP, that this is difficult about the powers available to civil servants when the Assembly wasn't sitting, but said, we're disappointed with that outcome. Anyway, February 2024, Assembly resumes. A month later, OEP then writes to the newly appointed minister now saying, look, you've really got to publish this plan. You're over a year late now. What's going to happen? There was still no progress. June 24, OEP escalated the case and it formally launched both an investigation and an information notice. That's the first stage of formal stuff. Now, the minister's response then was, well, the draft EIP, we've done it, but it's now with the executive. I don't have the rights in these internal arrangements to do it myself. And we have to wait for their draft programme of government to be approved before I can do anything. So it got stuck. And the draft programme of government was taking ages to negotiate and all sorts of things. So then what happened, and we do get the dates, Wednesday the 25th of September, the OEP board, including myself, and we have to approve all these notices, we met to say, should we now proceed to the next stage? Are we just being screwed around and the Assembly is taking too long to agree the programme of government and all of that? And shall we now move on to the third stage, the decision notice, which is the last before court action, and we'll give DARE a decision notice. And the Department and all that were well aware that this was before the board on that Wednesday. So it was in the knowledge. The board did decide, yes, we will authorise a decision notice and we'll serve it on the Monday. And amazingly, on the Friday, the programme was agreed by government. So I think that was an example. I was going to the wire. I think we would have won, actually, on that, given the Assembly. But, and it's one of these strange things, and those of you who know about politics, sometimes you get, particularly environment ministers, who quite welcome this sort of action, because it helps them, it gives them a bit more oomph against colleagues, and all of that. So, now, and these are some of the live cases, sewage discharges, good environment, big. And what I'd say is, I think my judgment is that OEP's had, I think, quite a lot of success. But it's not because it's confined itself to easy cases. As I said, the deadlines and legislation, I mean, that's easy. These are difficult cases. They're difficult areas of law. Lots of council's opinions had to be, a commission to look at it, to really understand it. So I think it's been quite bold on that. And indeed, there is, as I said, the website is there. You can see it all, but it's not easy. So I'm quite political underneath my legal side. I've done an article, just come out in the journal, but where I've gone through every single enforcement action, what did, I've categorised it, what were the results. Now, this is partly political, because I know there are people in government who do not appreciate OEP, who do not like it. And this is partly just to explain to both politicians, but this is really important work in my view. And indeed, rather surprisingly, The Spectator, which is a fairly conservative journal, last month said, you can see that nice quote, yellow quote, which is quite good to have on your front page. Now, it's actually not surprising, really, because Michael Gove, who was the Secretary of State who set up OEP, he's now the editor of The Spectator. So I'm sure he wrote that himself. Okay, now, some people would argue, and I've heard this other used, we can't, in our country, set up an independent public body, which then makes life difficult for government. It just doesn't work. Well, one of my arguments is that, well, actually, every member state has what are called supreme audit bodies, who are reviewing and reporting on public finances. And they often have a high degree of independence built into the constitution, in Spain, and even the Irish constitution. Now, these bodies, they don't take, well, most of them don't, legal enforcement actions, but they do make life difficult for government. They publish reports, and government normally has to listen, takes it seriously. So that's one of my arguments, that this is not unprecedented. And so I'm now, as I said, the strange thing is, I'm in this Avocetta group of European lawyers, and obviously I talk about the OEP. They say, what's going on in Britain? And I said, well, we've got this body, and they're, my French and German colleagues said, but we need something like this in Germany. We haven't got anything in Germany like this. We have to rely on NGOs, and that's difficult, or citizens, and there's nobody doing that. And we can't rely on the Commission to do all the work now, because it's not going to do the work. So, as I said, I'm trying to sell this concept, but I think it has to come bottom up in a way. I don't see this as outposts of the European Commission, because I think they'd be dealing with not just EU law, but national law as well. And I've got sort of two sets of principles I would make core principles, and then I think you design it as you want, because they're all different. One, that it has to be as independent from government as possible. I mean, nobody's completely independent. OEP is funded by government, and the chair is appointed by government. And the board members. So you never get complete independence, but as much as possible. The statutory duty to cooperate is very important, because that means they have to release documents and so on. And I think on implementation of environmental law, that's one of their functions, which will always be, and they must publish reports, and there must be a duty on the government to respond. I think those are the key things, and then you can do what you like. On enforcement, sorry, I'm just slightly over time. Oops. Sorry. And then on the enforcement, I think there has to be a duty to investigate. There has to be powers and means to resolve cases. I would ideally, like the OEP, eventually have a power to go to court. I accept that some countries, I don't know in Ireland, I know in Spain, they would say actually that is conceptually very difficult to have a public body taking a public body to court. That's not good. in a way, as a second best, I'd say, well, as long as they investigate breaches of law, they publish reports explaining why there is a breach of law, that may be sufficient, and indeed would let NGOs do that. And finally, they must publish a prioritization policy. Now, I'm sorry, I'm shameless in publicity, but these ideas actually are pursued in more detail in a new book on environmental law and policy, which is a leaflet coming out, which does the... Now, what I should say, this came out from the Eversetti group. Just two things, very briefly, I'd say about this book, which is quite interesting. It is not a comprehensive textbook on EU law. It's 27 specialists writing about their reflections and conclusions on lots of areas. And I was a co-editor, and it's quite difficult, though, you've probably dealt with that. I was saying to these people, you know, this is about you, what you actually think. You've been working at this for years. So you are allowed to use words like, I think, my view is. And a lot of lawyers find that very difficult because it's too personalised. But I said, this is much more interesting, and you can disagree. So that is in there. There's quite a lot of you. And the other thing is that all the authors they haven't got any royalties, but they've all given up any free copies. And the reason was that made the publishers said, we can publish this at under 100 euros. And that is 750 pages of law, which is a bargain. So if you're going to buy one book or you want to pursue this idea I've got, please, it's coming out next month, I think. Thank you very much. Thank you.